Stavros Makris. Welcome to Digital Markets Research Hub. You've been very productive and your papers are really shaping the nature of competition, the discussions on the nature of competition law, on the goals of competition law. You address in your research the foundational existential issues, trying to re-articulate, represent, rethink the issues which most of us are taking for a long time for granted. And the impact of these papers is huge, and it's a great opportunity to invite you to basically to offer an outline of the latest research which you published abundantly, but also I propose to do it through the prism of the problems. And the key problem which occupies so many minds in the field is the nature of competition law, the nature of competition, the nature of competition law. These two issues are inseparably linked, but they have two different pedigrees which you try to investigate separately to some degree. So without further ado, let me invite you to start answering this ever solvable dilemmas.
Thank you so much, Oles, for the kind invite, for having me here. It's a real pleasure and an honor. It's a channel we all, at least I, frequently visit, and I consider it extremely valuable because it enriches our academic community with a plurality of perspectives and very thoughtful discussions. So thank you so much for doing this and also for inviting me.
Thank you.
Okay, let me tell you a few thoughts about the nature of competition law. And of course, in that kind of question, there are several sub-questions. So let me refer first to a problem that I encountered also during my PhD years and occupied me quite seriously. And that was the problem, the phenomenon of reasonable disagreements. How can we explain that well-informed and in bona fide interlocutors on different sides of the antitrust spectrum reasonably disagree about the goal of the law, the particular application of the rules in specific cases, and even about enforcement techniques and practices and institutional design. And more than that, I also observed a paradox. For in my eyes, the modern antitrust paradox was that despite the fact that there is such stark disagreement on so many different levels, somehow these systems, and what I studied at the time was basically the European system and US antitrust, right? These systems operate quite smoothly, not without frictions, but as systems, right? They are resilient, they're adaptive, they adopt exogenous shocks, and they change also. They are capable of epistemic change. So somehow we can say that operates smoothly. So how can we reconcile these two phenomena? And in that case, to achieve this reconciliation, I delve a little bit into legal theory. And of course, it's a phenomenon just mentioned here. Others on the shoulders of which I have relied. So there are many other scholars that have been occupied by this phenomenon. So your work, obviously, right, something that inspired me also since my early master thesis years. Yes, of course, the work of Ioannis Llanos that talks about polycentricity, right? How competition law might be polycentric, how it adapts to changes. Ariel Ezrahi's paper Spawns, right? And also the discussion and the very interesting paper of Konstantinos Stylianou and Marios Iacovidis that talks about the multiplicity of goals and empirically maps out this, right? They all tackle somehow the same phenomenon. Of course, many others, just a few names that come to mind. So what I proposed in this paper, the Openness and Integrity paper, was that there are two ways to think of competition law. One way is the technocratic way, which you also criticize in your work, right? The technocratic way that sees it as a closed system of fixed rules, which might encounter frictions, but these frictions are to be addressed by incorporating value-free, objective knowledge from other epistemes, from other science, and this obviously is economics in this case. And according to this model, then the only thing we need to do is to apply the law in a crime tort fashion. So if we see infringements, if we see violations, then we punish them. And the role of the courts is to elaborate the norms. And then there is an alternative way, what I call the responsive law model, that sees the law as competition law as a purposive mission that is inherently, inevitably, epistemically and normatively open. And it is open because it has a fuzzy mandate. It relies on essentially contested concepts. It uses a conceptually elastic vocabulary, restriction of competition, abuse of dominance, and also it relies on an ideological science, and here I quote Hovenkamp, economics. So economics cannot be value-free, cannot be without any normative choices and assumptions. We always operate within a particular economic paradigm. So there are economics, it's not just economic knowledge, objective knowledge. So if we see competition law from this perspective, we understand that it's inherently open. But simultaneously, we see that the institutions of competition law, be that enforcers or courts, they continuously strive for what I call integrity. And here I use the term in the Dworkinian way. I understand it as principled consistency and coherence or substantive mission realization. So the institutions, they do not care about only about legality, about the letter of the law or just applying the rule as it is, but they also care about compliance that secures legitimacy. This is why we see also enforcers going beyond the crime tort model, and we see also courts refining the law. So it's these two forces, the openness of the law and the urge to secure its integrity, that produce reasonable disagreements. And of course, the law might be less or more responsive based on the capacity of the institutions to manage these disagreements. Because if we have too much openness, then the law becomes vague, or we instrumentalize it, or it becomes deconcentrated, right? So and by too much openness, I mean incorporating multiple goals without any proper analytical work, or without robust doctrinal developments. So in that case, we harm the integrity of the law because we undermine its clarity, we undermine its certainty, and also eventually the law will lose its legitimacy because the subjects of the law will not have clear rules to comply with, they will not understand the rationale of the law, so they will eventually start complying, right? Believing in it and complying it. So this concern is always there, I think, in the minds of enforcers and courts, that too much openness might disintegrate the law, but also too little openness might delegitimize them. So we see constantly many competition authorities behaving responsibly, as I call it, by incorporating new knowledge, by testing different tools, by organizing enforcement as a strategy that consists in strict enforcement, infringement decisions, and don rates, but also software and tools and sunshine enforcement. Also, we see enforcers incorporating new knowledge, and we see that the courts develop the law. So both enforcers and courts understand that too little openness might also harm integrity. So they try to harness some openness, but up to a level that will not disintegrate the law. Yes, and I'll stop here, sorry.
Can I just interrupt you for the sake of clarifying one important, for my understanding, thing? This is a descriptive thesis. You describe the system. It's not something which you propose. That's how competition regimes function. Yeah, and I wonder if there is anything else would be pathological in your view. So too much openness would make the system unpredictable, completely or not completely, too instrumental. There will be no continuity. It will not be embedded into societal matrix. Too strict legalistic would make it mechanistical, axiomatic, and not reflecting the challenges and not delivering on its mission and mandate. I wonder, is this pathology, are these pathological situations even possible? Is there any condition which could be in reality similar to such theoretically very plausible pathologies, or the law itself will somehow digest and fit these discrepancies or these irregularities into its system and adjust it and polish and make a new reality? And is it important to presuppose the plausibility of such irregularities, or they are just present as the theoretical polarities allowing you to shape the argument?
No, I think they are very present concerns because, for instance, and just to give an example here, now that we are discussing digital markets, right, and there are a lot of development of the case law and of our enforcement practices in this kind of terrain, I think the urge behind that was that if we apply the traditional neoclassical framework that only looks, for instance, at price and output, we are missing something. So enforcers started understanding. They were quite aware, in my view, of the concern that they will not be satisfying their mandate. They will not be actually realizing the mission that is entrusted to them by the law if they don't look beyond the conceptually elegant and robust, but always with some kind of blindness, neoclassical economics framework. And it was actual reality that made them do this step, right? Because when you see, for instance, digital platforms bringing up new economics with extreme return to scale, network effects, the role of data and AI, then these kind of technological developments and features of digital markets create new capacities, new strategies to incapacitate rivals and exploit consumers. So these developments also call for epistemic change. So we need perhaps new tools, new concepts, and we also need to refine our existing tools to accommodate this concern. So we harness law's openness to capture that, right? And just because I give you an example of too much closeness that can illegitimize enforcement and in general the antitrust enterprise, but also we have plenty of examples where too much openness is a very tangible concern. Because in most discussions, when we have, for instance, a privacy-related matter or a sustainability-related matter, the chief objection that enforcers legitimately, media pluralism as well, legitimately bring on the table is that our mandate is to protect effective competition, and I completely side with that. So I'm not here to protect the environment as such. I'm not here to protect media pluralism and democracy as such. So I don't want to usurp my power and create democracy issues, right? Undermine the democratic setup. So they are quite aware about the pitfalls and the dangers associated with too much openness, right? Many of them they incorporate these concerns in an organized way, but maybe we'll discuss about this later on.
Okay, and then the question in this regard is this: if we assume that it's a descriptive thesis, yeah, that's how the system. Well,
Not only,
I
but yeah.
understood from your answer that it's also a normative, that because it's not necessarily the case that the system is open and integrated, integral. Should I, as an enforcer of competition law, be driven by this broader societal interest? Is it something? Is law can be an obstacle for me to deliver such issue, such goal, such on such mission, or I should always be subsumed to the law as integrity, and thus somehow being part of this broader. So the rule of law prevails over the political, not even necessity, over political reasonableness, over the need to deliver on something which is on which I have my professional reflection. Am I just an enforcer, or I'm also a co-creator of the market?
Okay, plenty of very interesting questions. Let me try to answer this and unpack here. So let me first highlight that the framework I propose in these actually two papers, the Openness and Integrity and the other one, the EU Competition Law as Responsible Law, is both descriptive and normative. The descriptive part comes from my motivation to reconcile myself and explain somehow this phenomenon of reasonable disagreement that I just mentioned, and also dispel some patterns of thought that do not help us properly understand the phenomenon, what I call the autonomous law model, right? Because the autonomous law model actually it's a pattern of thought. If we think of the law as a closed system that is supposed to incorporate technocratic knowledge and we will eliminate frictions in that way, then this is not, it doesn't capture how competition law evolves, right? This is one claim. But then the other part of the paper focuses on how to tame or manage reasonable disagreements. And there, I proposed a legal institutional modus operandi because, as you nicely put it, the system might be somehow responsive because there is this inherent tension between openness and integrity, but how well behaves, how responsive it is a matter of ad hoc assessment, right? So we need to develop specific benchmark standards or principles and then assess and see what is happening on the ground on this particular system to assess its responsiveness. That's why what I'm saying here is that I somehow propose a system not only to see what is happening, but also to evaluate. So my recipe, the responsive law recipe to deal with reasonable disagreements consists in a legal institutional modus operandi. And the assumption there is that only refinements in legal interpretation will not suffice to deal with reasonable disagreements. I talk more about refinements in legal interpretation in the recent paper on interpretivism, on competition law as argumentative practice. But in this previous paper, I focus on enforcement and adjudication. So what I say there is that we need, in terms of interpretation, adopt constructive interpretation. Let's discuss that later. And then when it comes to enforcement, enforcers need to behave responsively, and courts need to operate not simply as norm elaborators, as the traditional conventional autonomous law model would claim, but also as orchestrators of argumentative struggles and also as checkers, as responsiveness motivators. And what do I mean by responsive enforcement is something quite concrete. So there I rely on the work of Iris and Braithwaite, but also of others. And what I mean by that is enforcers that do not focus only on punishment and deterrence, but also on compliance. They go beyond the traditional and very textbook, I have to admit, divide between ex ante and ex post enforcement, prescriptive and proscriptive, and use a wide variety of goals in order to do what? To secure the law's integrity, right? To materialize the law's goal, protecting effective competition, in a rule of law compliant way. And to do that, they need perhaps to use a mixture of market investigations and sector inquiries with commitments and perhaps an infringement decision, learn from the market. For instance, commitments with a market testing procedure allows enforcers learn from the market. And we see that in the digital context, that enforcers are more and more open to learn from civil society actors and NGOs and complainants about the workings of the market. So learning from the market, learning by doing, so revisit their performance. And we see the Commission conducting studies, impact assessments of its enforcement practices in particular areas quite regularly. So this is another responsiveness feature, and learning from others. You can learn from another enforcer, and this is why we have the ECN, but also you can learn from another regulator. And we see now in the more complex regulatory landscape that enforcers learn also from data protection authorities. And on this basis, for instance, just to give you a concrete example, I looked at another paper at the workings of the Hellenic Competition Commission. So, and I tried to see, is this authority behaving responsively? And what do we mean by responsiveness? And what I observed there is that we talk about an incredibly rich in strategies and like workings authority that do not only conduct and increased, based on the periods I identify in the paper, its done rates and infringement decisions, but was also mindful to decrease the duration of the proceedings, also publish guidelines about compliance, right, to help associations of undertakings, for instance, to comply with the substantive elements of the law. Also guidelines about enhancing competitiveness that were addressed to the state. They also used plenty of sector inquiries and market investigations, commitment decisions. So this pyramid of escalating threats that I mentioned before, but also they invested in epistemic capacity. So they organized seminars to learn about computational methods and incorporated computational methods, for instance, with a digital platform on whistleblowers or with a digital platform that was monitoring particular markets so as to see what's happening with pricing practices, for instance, and also with this sustainability sandbox. So then we talk about an enforcer that intervenes in these multiple levels, ex post and ex ante, seeks to secure compliance, but according to the original Iris and Braithwaite theory, you cannot secure compliance unless you carry big stakes, unless you have also capacity to impose fines and run the cases effectively and defend them before the court, right? So you don't have, you should not forget this other side. And based on that, I try to see how responsively the Greek authority behaved, and this was my finding, right? That we see all this rich activity, right? So we definitely talk about a responsive enforcement there.
Okay, so let us keep this example as an illustration of what you call responsive enforcement. And let me contrast it with a hypothetical authority of country X, where you don't dedicate your time and resources to managing and fine-tuning the system, making kind of to good governance, where you are ruthless and categorical and bold and aggressive, but you pursue a goal which you consider being an important goal for, let's say, increasing competitiveness of your country, let's say in digital markets. And you shape competition proactively by channeling compliance in a specific fashion, by cherry picking, by acting frivolously as an enforcer, by using this very rich toolbox based on your understanding. So you are a policy maker, a politics maker. Is such conduct ultra-virus? Is such conduct would this conduct be compatible with how you describe the system? And if not, and I assume it will not, where would you see the pathologies? Where it will go beyond the framework?
We have this is a very interesting question. We have a very effective guarantee, systemic guarantee against this kind of trends, which is judicial review. So authorities have capacities to prioritize and ambit to prioritize cases or focus on specific sectors of the economy based on their like agenda, right? And this is a legitimate concern. But if they instrumentalize the law or violate fundamental principles such as equality of treatment, for instance, I'm quite confident that in most jurisdictions, courts will step in to rescue the system, right? And then there would be this feedback loop between enforcers and courts, and this will bring the system back, let's say, to somehow in equilibrium. So my response there is, it is legitimate first to exercise some discretion and prioritize specific sectors or concerns based on the economy, because this is also what the market context might dictate, right? So for instance, big tech players might be very different in Africa vis-a-vis US, or you might have different policies towards vertical restraints and platforms in specific markets based on the market environment. So this is a legitimate concern, and it's also very much dependent on the market features. But I think also enforcers, as long as they are explicit about their underlying normative choices, they will be kept in check. And what do I mean by that is, if an authority comes in a responsive way, right, and says, now we want to prioritize consumer welfare, or a thick conception of consumer welfare, or consumer welfare, but in a way that incorporates sustainability concerns, and does that in an organized way by issuing a guidance paper or guidelines, right, to secure that the social norm that they try to bring up is understood by the subjects of law, and it is not abrupt, and there is a transition period, and then they test some cases before the court, then the court, I'm quite confident that the court will be there to allow this shaping, these refinements, without the rule of law principles and values being undermined.
Okay, and then the factual question: do you think any enforcer would be capable, leaving aside that it secures the legality and legitimacy of its, I wouldn't call it frivolous, but it's very proactive modus operandi? Do you think they would be in the position to shape competition in digital markets, let's say, proactively? Their knowledge and skills would allow them to deliver on this ambition, and also maybe not only competition in digital markets, but digital markets themselves.
Okay, that's great. So first of all, let me clarify something. In my understanding, I'm not claiming that enforcement should always be prophylactic or more interventionist. I'm just saying that omissions are also shaping market realities. So if you act or not as an enforcer, your behavior will have an impact on the market. So if you decide to pursue, for instance, consumer welfare or consumer welfare sustainability, or you decide not to incorporate any sustainability parameter, no matter what you do, your choice, the underlying choice, there is an underlying choice, there is an underlying value judgment, will have an impact on the market. So this is a leitmotif of my work, that I consider that value judgments are inescapable. They are inevitable in competition law. But we have ways to do them in an organized, objective way, reflexive way, check them, recalibrate them, and make them explicit and transparent. Now, let me answer directly to your question. So I think that as the market becomes, and the markets actually, market realities become more complicated and more complex, we are also playing this catch-up game. And we see that enforcers are investing in epistemic capabilities. There are a lot of enforcers that are authorities that are doing pioneering, groundbreaking work. They incorporate concerns, but also, as I said before, they might decide not to apply the law in a particular area, like sustainability agreements, right? Private sustainability initiatives that should not be chilled, for instance, for alleged or purported competition problems that are not actually competition problems. So there, for instance, we had the Dutch authority, the Greek authority, we had the European Commission that published Chapter 9 in the guidelines on horizontal agreements, which for me it's a very nice framework. We might have, like, we can discuss the nitty-gritty and the details out of market efficiencies, the fair share to consumers, sure, but overall, it's a very nice framework to analyze sustainability initiatives, sustainability standardization agreements, and not apply the law, right, in that case. So this, for me, is also a responsive enforcement. This enforcer also incorporates some concerns, so invests on epistemic capacity, and we see that playing out quite nicely. And the last bit of your question was about digital markets. So in digital markets, we see a very complicated landscape with DSA, DMA, GDPR, so many, and also multiple jurisdictions that might have also national tools or their own priorities and agendas. Somehow we need to organize the system. I'm not saying that is well organized at the moment, but I'm saying that we need to organize this system, and through a network of enforcers, we can increase the system's learning abilities. let me give you an example on that. An example from traditional competition law. So, which is simpler, right? So when it comes to MFN clauses in online travel agents, you know that there was a fragmentation in the approaches adopted by the competition authorities. So the Commission stepped back, and the German authority pursued both broad and narrow MFNs. Other authorities went for commitments, whereas the German authority went for infringement decisions. And they had also a different logic, right? So since the welfare effects of MFN clauses on online travel agents are mixed and ambiguous, we have to learn. And we can learn through market testing. Commitments, they have this market testing, and enforcers learn, but we can learn from difference. So one jurisdiction follows one approach via commitments, another follows an infringement procedure. They have also a different take, a different attitude to MFN clauses, and then they revisit. After this, somehow, one might say, fragmented way of applying the law, the Commission conducted a survey, right, about the impact of these decisions on the relevant markets. And then also we had a crystallization about MFNs, at least when it comes to big platforms, right? So this is how the system learns. So I am moderately optimistic about the capacities of the system to learn. And I'm not talking only about like the individual enforcer, but also the system as a whole through a network of enforcers. Of course, there is a serious problem because most authorities are understaffed, right? Digital issues are fairly complicated, so we need to up our game. No discussion about that. But it's also a matter of political will, right? Funding, political will, staffing the authority. So it's a question that is not also easy to answer, right?
But okay, but then as an enforcer of the DMA, do you have to focus on compliance with? Is for you the goal of the DMA, the goals of the DMA being achieved when you deliver on compliance with all obligations of Articles 5.7, or you look at the compliance and obligations as a means, as a stick, as you suggested, to shape competition and to use them as a policy tools to nudge perhaps or to encourage and maybe use as a bargaining chips on other occasions. So are obligations the objectives in themselves as small objectives, or they are instruments?
Great. Thank you so much for this question because it clarifies also this contrast I make between autonomous law, crime tort style of enforcement and responsible enforcement. So I would say the second one, what you described with your second example, is what we call responsive enforcement. An autonomous law enforcer, a crime tort enforcer, would say, okay, we have a laundry list. So where there is a deviation to the letter of the law, I have to apply the letter of the law, period. Whereas what you described afterwards was what, in my view, is a responsive enforcer that sees the obligations and sees also that there are underlying objectives, right, that permeate these two, fairness and contestability, that are not always entirely clear. Their content is not always entirely clear, but the vision somehow it is, right? So we talk about an enhanced and simplified, as Giorgio Monti put it, competition law 102 framework, but it also goes beyond that. When, for instance, we talk about fairness, we can see that the DMA incorporates conceptions of fairness from other legal instruments. So we have this creature. And then the responsive thing to do, also based on the institutional capabilities of the enforcers, right? Because I doubt they're fully staffed to go after every single obligation, right? Is to target specific obligations that make maximum impact. You learn from them and you also deliver results so that you show to the big tech, you show to the platforms that there is some rationale behind this particular obligation. This obligation made a difference. Here it is, right? We reviewed our performance and we see that the market behaves better after the implementation of the obligation, and users or business or end users are happier. So we have a better ecosystem after the enforcement activity vis-a-vis vis-a-vis before. So a responsible enforcer would be one that is motivated by principles, is open, organize the strategies from sunshine and soft to stricter approaches, but also targets specific areas that have maximum impact on the market, on our lives, and also on their capacities to learn. So that would be my answer.
Okay, and continue with this example. Let us take a meta non-compliance case where their arguments are quite categorical. They basically say that it's a punitive means to encourage contestability, essentially, because you don't deliver any positive outcomes to business users, to advertisers. You basically make our services worth. You put a heavy burden on our shoulder because you want to enable access maybe to social networks market by some newcomers, etc. Probably. Is this a legitimate? Of course, you can tick the box that there was an instance of non-compliance. As an enforcer, you can prove the case. But is such selectivity, such smart and Machiavellian targeting of a specific conduct of specific gatekeeper, implying that you can probably identify others? Is it not from legal juristic perspective, but from the kind of policy making perspective, is it the way to do the business? Or you would be expected as an enforcer to be proportionate and to look at all core platform services, at all designated gatekeepers? So you have to maintain more or less equal play and thus disseminate and disperse your resources, or you have to be more cynical perhaps in pursuing what the legislators have entrusted you to deliver.
Okay, I think there are two separate issues here. One issue and one concern is that inevitably the authorities will have to prioritize, and they can do that in an organized and thoughtful and objective way. And you cannot, let me put it that way, go after everyone vis-a-vis any possible obligation. Maybe because you have institutional constraints, and because of that, you will have to make some decisions, and you can be strategic there. And my view there is you have to prioritize, as I said before, behavior that and change that will make the most significant impact, will deliver results, and will help you learn. And again, it's not about punitive, it's about learning, or organizing a regulatory conversation and delivering results. The other thing is you have to always be mindful of not only satisfying the rule of law requirements, equality of treatment, but also displaying this, right? Giving this, signaling this idea, because this will have an impact, as we see also in the current geopolitical setting. It will have an impact on EU-US relationships. Perhaps it might make the whole DMA a carte blanche, right? We have seen this kind of attempts. Also, it will be the wrong way of doing business, right? Because this is a rule of law jurisdiction. So a rule of law jurisdiction doesn't mean that we might not prioritize, for instance, food markets vis-a-vis luxury item markets when it comes to cartel practices, right? It's inevitable that we will make this kind of, enforcers will have to make this kind of choices. But if you target one particular line of supermarkets and you leave the others, and we can identify a systemic bias, then there is a problem. Then we have a problem. And then I think we should assess. I cannot answer whether there is a problem or not. My impression is that the European Commission is not targeting particular companies just because of their place of establishment or nationality, etc. But this is an empirical matter, right? So it's something that has to be assessed.
Okay, so let us now return to your research, and in the latest paper, Competition Law as Interpretive Argumentative Practice, forthcoming in a collected co-edited volume which you co-edit with Elias Deutscher and Just Lindenbaum, you again return to a grandfather of legal of contemporary legal thinking, Ronald Dworkin, and you engage with his vocabulary and with very helpful way how he uh, explains the law, and you transpose many pivotal observations to the area of competition law very, very helpfully. So can you please explain the key ideas of this paper?
Thank you, thank you so much, Oles. Thank you so much. And thank you also for contributing to the book with Elias and Justin. It's soon to come out. So in this paper, I continue a bit, and I mentioned it in the beginning of our chat. I continue a bit one strand, one theme, one concern of the responsive law or openness versus integrity framework. I mentioned before that the modus operandi that I proposed was a legal institution, and we talked about responsive enforcement. But I said something about constructive interpretation, and I didn't explain further. So thanks a lot for giving me the opportunity to explain that. And also, I wrote this paper because I was quite concerned about how we can understand and what kind of benefits we can derive from constructive interpretation. So let me tell you first what is the idea behind the paper. It's a thing that fascinates me, which is how judges arrive to the content of legal norms, how they make this journey from 102, the text of 102, based on the facts of the case, to this particular judgment. In 102 now, let's take the example of Coty, for instance, in 101, excuse me, but in 102, let's talk about refusal to supply. How the judges derived from the text of 102 that, for instance, there could be an abuse in the setting of Android Auto, or how could they articulate the so-called Bronner conditions, that if you request access to an infrastructure, this infrastructure has to be indispensable, meaning has to be duplicable by an as efficient competitor. Otherwise, we cannot impose a duty to deal because there will be a free riding problem. How did the judges come up to this kind of pronouncement, and how did this pronouncement change somehow in Android Auto? Because in Android Auto, for instance, the court said if you have a platform that is partially open by design, so you have promised to third parties that you will accommodate their platform, their apps, then indispensability is not required, right? Someone might ask and might look at the evolution of the case law and think, okay, the judges are just splitting hairs here. We talk about an infrastructure here that the indispensability requirement played a role. Here, the infrastructure is slightly different, but isn't it freedom or economic freedom or freedom of property that dictates a similar standard? Isn't the remedy imposing access that is similar to address both problems dictating the application of the Bronner conditions to that case as well? As, for instance, also Google frequently argues in this kind of setups. So this is an example, but we have a bigger problem here: how to explain the evolution of the case law. And I took issue with two particular ways to explain the evolution of the case law. One is a top-down axiomatic approach, and the other is bottom-up doctrinalism. This is the terminology used in the paper. So the top-down approach says, it's more or less a Dworkian style approach. Says if we decide on the goal of the law, if we have value singularity, then through doctrinal analysis and input from economics, judges can determine the content of the law, and input from economics doesn't rely on any value judgments, so the application of the law is an objective value-free exercise. Then we have a bottom-up approach that tries to avoid this kind of normative debate on deciding the soul of antitrust and a particular goal, and says, let's skip this debate, look at how the judges decide cases incrementally. So this is why I call it bottom-up doctrinalism. From one case, judges jump to another and jump to another. And the selective distribution agreements that I gave you as an example before in the beginning, right? We have, for instance, Metro 1, then we have Coty. So an incremental development. We have commercial solvents, then we have McGill, Bronner, Slovak Telecom, Google Shopping, Android Auto. This incremental development. But I think that both approaches fail to explain how the law evolves because they rely on legal positivism and economic formalism. Sorry for the jargon here, but by legal positivism, I will be very clear. I refer to the position that the determination of the content of legal norms is only a social fact. No value judgments are included, the legal positivist position. And no argumentative struggles or interpretive choices are included. They are only included if the source of the norm, which is a social fact, gives this power to the judge to incorporate this moral argument or this economic argument. This is the positivist position.
But can I just very quickly? Okay, I see how the bottom up approach can be seen as positive, kind of hardcore positive, legal positivism. But if you look at this top down axiomatic approach, they somehow try to look at their legitimacy they take its legitimacy from economics. So they are economic formalists, yeah. So and yet you fit them together with legal positivists.
They are okay. You are right that they make one normative judgment, right? They make one normative judgment, but a positivist is not categorically against normative judgments. A positivist, vis-a-vis, for instance, Hart or Kelsen. Kelsen would tell you there is a King's Midas argument. If the norm, or us also, would tell you if there is a norm that gives discretion, mandate to the decision maker to incorporate extra legal knowledge, then this has been transformed into a legal norm in that way. So the determination of the content of the legal norms remains a social fact. What I take issue with is that the determination of the content of the legal norm is not a social fact, is the byproduct of argumentative struggles and struggles between competing interpretive theories. So the law is an interpretive fact and not a social fact. And this might sound a little bit abstract, but that's why I want to return to the refusal to supply example that I gave you. So if we follow the top-down axiomatic approach, then I cannot really see how we can explain the term of the court in Android Auto. So did the court there use a particular value, consumer welfare, and said, okay, consumer welfare dictates a different outcome here? I don't think this is a fair reading of the case. Also, bottom-up doctrinalism will make the case non-understandable. Why? Because someone might very legitimately say, okay, so is it the reason that this platform was designed to be open first and then, or partially open, and then close something, the reason we don't have to apply indispensability? What about effects analysis, right? What about the remedy that is an access remedy? How can we explain this kind of judicial pronouncement through incremental development of the law? I think bottom-up doctrinalism can only ex post rationalize the law, but it cannot explain. And why do I claim that an interpretivist account of the law can't do that? Because an interpretivist account of the law tells you what? There are different interlocutors, enforcers, plaintiff, defendants. The judges the judges are arbiters, but they can also be constructors of interpretive theories. So these interlocutors create a narrative about the law, about the case, that reconstructs the purpose of the law in light of its effects. And this interpretation, this narrative, tries to fit prior cases and justify the law. Again, you see here integrity concerns, right? Because the players are interested to argue, reason based on previous cases. Analogy is a fundamental method of legal reasoning. So they have to show that what we decide or what we require has already been decided somehow, or the cases are similar or they are not similar. That's why you should decide differently. And the judges, of course, they have to use this language to show that their pronouncement is part of a chain novel, right? So they are very, very careful about the fit requirement. And we see also that in the Android case, the judges, they don't dismiss the Bronner criteria, right? They maintain Bronner and they get into deep trouble, let's say. They put a lot of effort to reconcile the previous case law with this somehow new approach. But I haven't answered on the question why, right? Why did the Android Auto court went that way? So applying the theory, my point is we talk about a different interpretive theory that was deemed by the court as more fit for purpose. What do I mean by that? If we look at the facts of the Bronner case, we talk about the brick and mortar market. Mediaprint had developed this infrastructure. Mr. Bronner, who now has an online channel in Thrives, right, an online outlet of his newspaper in Thrives, required access, and the court there looked at the incentives, said if we make access too easy, we'll create a free riding problem. If we make it too hard, we eliminate downstream competition completely. So the concern of the court was to protect downstream competition, right? Also, it made some assumptions about the relationship between competition and innovation, or the structure of incentives related to standalone innovation and free riding problems. And essentially, the court said, I will be imposing a regulatory duty, access obligation, when we have something akin to a natural monopoly, if the facility cannot be duplicated by an as efficient competitor. Okay, this was a reasonable solution to a brick and mortar related problem. Now we have digital markets. So the court increasingly, this is my claim here, we can see that in many decisions, I can support it further, but the court increasingly understands innovation in digital markets as cumulative and collective innovation. So we have these nice paragraphs in Android Auto where the court assesses the incentives to innovate and says, if we remove the indispensability requirement and we impose a circumscribed obligation to provide access, this will not undermine the incentives to innovate, because these kind of platforms create value when the access is shared, when they provide access to third parties. So the court here looks at innovation incentives, looks at the relationship between competition and innovation. So in the brick and mortar market, we have standalone. Here we have cumulative and collective innovation, and changes its notion of harm. The harm in the Bronner case is a dominant company preventing all competition downstream. The harm here is acting as a private regulator, acting as an ecosystem, and dictating the direction, the pace, and the features of innovative activity. And by that, hampering innovation incentives and consumers. So it's a different type of harm. Choice in innovation is much more prominent here. And on that basis, so the different conception of innovation and the relationship with competition, and the different understanding of competition harm, the court comes up with a different notion of competition on the merits. Because competition on the merits in Bronner is, as long as you are less efficient, I can exclude you. I can enjoy platform or infrastructure exclusivity. If you are as efficient, or if no efficient player can replicate that, then a duty to deal can be imposed on me. In Android Auto, competition on the merits is very different, because I have a duty, a fiduciary duty, to treat everyone fairly because of my ecosystem platform power, and because I have created some legitimate expectations that third parties will be able to operate in my infrastructure, right? So there, competing on the merits is different. Do not exclude unless you have an objective justification when you have developed an infrastructure that is open or partially open, right? So we see also the meaning of competition on the merits changing. So my bigger point, and I'm sorry, I will stop with that, is that the interpretivism, so looking at fit and justification and understanding competition law, not just as a set of rules that are applied with some input from technocratic knowledge, but as a terrain where different interpretive theories that are a mixture of value judgments, doctrinal analysis, and input from economics that can be value-laden or non-value-laden input, these kind of argumentative struggles crystallize the byproduct of the law, and this might also change, right, later on. This framework explains better the law, and also this framework avoids something that I think this is not entirely helpful, that the bottom-up approaches or top-down approaches do, is you cannot assess the additional result, or if you adopt one single value, then the law becomes a closed system. So we have the pretense or the feeling that the law progresses rationally. One decision revises the law, makes it more rational, and we go further. Or if it is not rational, then there is one right answer. The interpretivist framework tells you we have different value judgments. These value judgments might give rise to different interpretive theories, and there is no one way to determine once and for all the one right interpretive theory, because we have this value judgment, not only because markets change or the context of the law changes, but also because value judgments are byproduct of these argumentative struggles. So the only aspiration we can have is to make these interpretive theories explicit and be reflexive about them, so change them accordingly, not pretend that we have found the one right answer.
Okay, so two clarificatory questions, Stavros. The first one about the bottom-up approach. What, as a good, diligent, and consistent doctrinalist, what should I be doing after the judgment? I incorporate it from purely descriptive perspective. I incorporate it in this kind of chain of development, and for me it becomes a next, maybe not chapter, but maybe a next volume of the same novel. Yeah, the next. So it's new important milestone, and thus we start. But I continue. So doctrinalist, I understand this as a means, as the perfecting the language, the vocabulary of case law, the casuistics of case law, and also referring to economic glossas and factual expert knowledge to justify your position, implying that there is not necessarily only one right position, but you select the one which your client wants. Okay, I move to another dimension of this. Okay, that's the first one, but the second will be about the role of judges in this constellation which you explained. But maybe let us stop with doctrinalists.
Okay, first of all, let me stress that doctrinal analysis is paramount, and we should not, of course, avoid it or underplay its relevance. Actually, the paper I wrote for the edit volume you published on pro-competitive effects is only based on doctrinal analysis and how this concept of pro-competitive effects has evolved in the case. So I see tremendous value in doing doctrinal analysis. That's why I talk about the fit requirement in the constructive interpretation framework, right? So I'm saying a constant concern would be fit, right? So some cases fit with prior cases, right? This is what Dworkin meant with this requirement. So many cases could be decided by analogy, as we discussed before, by identifying similarities or dissimilarities and extending the law as long as the underlying reasons and assumptions have not changed. So it's doctrinal analysis is very important to see what we have there, and also it can help us deal with several cases through incremental development, right? if the traditional methods of interpretation, textual, right, analogy, extending or reducing the scope of the law, some teleological thinking, historical, maybe, even though I have some concerns on the value of historical interpretation, but as long as traditional methods of interpretation can sort out the issue, doctrinal analysis will deliver. My point is that it will not deliver in hard cases. And by hard cases, I don't mean factually sensitive cases or cases that the factual matrix is very intricate or the stakes are high. I refer to cases where there is valid disagreement about the propositions of the law. So there is valid disagreement about the content of the law. So we might have a valid disagreement about competition on the merits, the as efficient competitor principle, if there is such a principle, etc., etc. So in these cases, the doctrinalist should go beyond the internal point of view in Hart's vocabulary, simply doctrinal analysis, and unpack the underlying value assumptions that have been made in the decision within this particular context. And I see this as a transparency project. If you do that, you will better understand the case law. So for me, it's an enhanced way of doing doctrinal analysis, right?
Absolutely. Okay, but moving on with this, once we agree that there is, as a decision maker, as a judge, once I adjudicate on a hard case, well, I think that you can, when the stakes are high, you can problematize and offer an alternative reading of previous cases or any positive norms, legislation, and also you can blend. If you are skillful master, you can blend of identical ingredients, very different final products, and obviously, when the stakes are high, you have the luxury of refer to the expertise of the most skillful grossmeisters. But that's which makes my job as a judge even more challenging, perhaps. So if there is no any more axiomatic beliefs in belief in existence of one answer which is discoverable, my mandate becomes not my normative mandate becomes broader. I can decide. I'm expected to decide based on if both sides offer a convincing and appealing and doctrinally underpinned by doctrinal analysis and economics interpretation of what happened and what should be adjudicated, what should be my answer. Where should I seek for the inspiration or for navigation? Who should be my moral or normative navigator in this case?
Okay, that's a very interesting question. Uh, First of all, just to highlight something, you are right to say that in decisions, the way decisions are drafted, we see in the way also judicial reasoning plays out, we see what I call different interpretive theories coexisting. So we might see, let me put it that way, consumer welfare arguments coexisting with protecting competition as such argument, and somehow using all the different sources to justify the solution given to the problem. And of course, a judge naturally will try to avoid polarization and take one view here, right? But one point I make here is that using blurring, because you said that in the beginning, blurring these boundaries or using this kind of blurry language too much might be counterproductive at a larger scale of things because we cannot really test the interpretive theory. Still, however, it's fine to use the overlapping justifications. We can identify, this is what I try to do with Android Auto and Bronner, we can identify the underlying interpretive theory, right? Which often will not be just consumer welfare or competition as such. It will be more sophisticated, right? Making assumptions about specificities. So I think it's important to identify the interpretive theory, not because we can find the one right answer, but because we can find less erroneous or more erroneous answers. So this is my take here. My take is that adjudication is more of an art of persuasion, and judges have to exercise judgment. This is why we trust them, right? To exercise judgment. It cannot be, you cannot find a clear-cut algorithm. We can try, but we cannot find a clear-cut algorithm that will deliver the one and right answer. So I think cases will be decided always also on the basis of this persuasion element of like fair judgment that goes beyond any very scientific, I would say pseudo-scientific pretense that adjudication can be a mathematical procedure. Even now, cutting-edge science doesn't have this pretense of objectivity. By saying that, however, I do not mean that judicial decision-making is subjective. Not at all. I say that we can assess it, right? And then you ask me, can we have a moral compass? It's not my intention here to give a more specific moral compass, because this framework, interpretivism, so competition law as an argumentative practice, seeks to encompass the nature of judicial decision making. So we might have, let me put it that way, an interventionist, progressive judge that sees many public interests and wants to see many public interests in the law. And this judge might be a positivist or interpretivist. And simultaneously, we might have a conservative judge and this judge also be an interpretivist. I think with interpretivism as a framework, we can understand better the nature of argumentation in competition law. I don't want to say that interpretivism will deliver progressive results or conservative results. This is not at all my intention. Now, if you ask me about the moral compass I would like to see in competition law, this is not in this paper, but I have said a few words about that, inspired by the work of Adam Smith. So in that regard, my personal view, again, is that competition law should, the primary goal is protecting effective competition, and this should go beyond incorporating consumer welfare concerns to extend to competition relevant public interest goals, such as sustainability or media pluralism, and also protecting freedom as non-domination and most vulnerable consumers. I found the work of Adam Smith very helpful, very inspiring in that regard, because in contrast to the, I would say maybe general view towards Adam Smith, what I call in the paper the Chicagoan straitjacket, we tend to think of Adam Smith as the not only the father of modern economics, but also the proponent of, or the most stark and significant proponent of self-interest, and a proponent of free and regulated market, where the invisible hand of the market, the pricing system in Friedman's and Stiglitz's words, will deliver. And also as a proponent of limited governmental intervention, because politicians are corrupt. Of course, Adam Smith criticized heavily mercantilist politics and policies and statesmen and politicians that were corrupt, and they were generating unintended consequences with their interventionist politics. But the heart of Smithian thought doesn't lie, in my view, and of course there are others. There is a very interesting literature pushing this point. Amartya Sen also has, of course, made this point. The heart of Adam Smith's thinking is freedom as non-domination. So is using markets as emancipatory institutions that allow for independent decision-making. So Adam Smith gives this example of the person that wears different clothes and says, in the feudalic system, you are dependent on few players. But in the commercial society, you are dependent on 1,000 suppliers. So you are not effectively dependent in any of them. And now you see the relevance of Smith in the current, I would argue, techno-feudalist framework, where we see markets turning from public domains where dependents were very limited to enclosed spheres where servile dependency in Smith's work is very high. So that's why I think Smith's concern on freedom as non-domination is very relevant for us today, because we have this new wave toward techno-feudalism. The second point, and I'll stop here, is the concern about most vulnerable consumers. So Adam Smith was also a moral philosopher. He wrote about empathy. So his second most famous work is the theory of moral sentiments. So he did a lot of work on how moral sentiments and judgments about the right and the wrong are developed, and he identified that in the mechanism of empathy. So in my view, it would be a misunderstanding to focus only on self-interest. But even if we read only The Wealth of Nations, there is this interesting passage that says the commercial society succeeds in making the peasant in this society more better off, enjoying better living conditions compared to the African king, the language of Smith, right? That is the master of 1,000 slaves. So the reason he praised commercial society is not simply the maximization of an abstract consumer welfare. Of course, prosperity features very, very prominently, but also the improvement of the living conditions of the least well off. I think this second concern can lead to a serious recalibration of competition policy by incorporating a most vulnerable consumer standard. We have some enforcement activities in that regard, and there is work in that regard. But if you ask me for the moral vision of competition law, is this a moral vision that incorporates values that are competition relevant, such as sustainability or media pluralism, market resilience, looks at effective competitive constraints as a way to incorporate freedom as non-domination concerns, and also complements consumer welfare with a concern about the welfare of the most vulnerable consumers. This can be incorporated or it can be antithetical, and it can be decided on a case-by-case basis. But this is my personal take, right?
And I should also note that pretty much all of the ideas which you have presented in today's conversation are being already uh, shaped in the form of articles published in the top tier journals, and they are available, and we'll provide links to all of them
Thank you
in the
so much.
description to the video for the convenience of those who will be interested in looking deeper and in a more relaxed fashion on the development of these ideas. The last question on this part, Stavros, you had a very fruitful exchange with your good friend Justin Lindeboom on the question whether competition is an essentially contested or contestable to different readings concept. Can you please quickly explain to why whether it is and what's the reason for deciding on this matter?
Okay, probably I would not make full justice to Justin's argument. He wrote a very interesting paper on competition as an essentially contested concept, right? And his argument, which in the end, I mean, we had also chat afterwards. In the end, I think we are on the same page. But his point was that competition as such, as a concept, is not an essentially contested concept. It's the adjectives or the broader theory that creates the contestation. Um, so, I mean, if we put it that way, I fully understand and I agree with, to some extent, I agree with Justin's point. The paper is really brilliant. But here I have to stress that there was a different aim between us. So I think Justin's aim, and maybe I'm wrong here, but Justin's aim was the aim of analytical clarity. So he identified a confusing analytical point, and he made an argument to dispel the ambiguity there and the confusion there. And my concern was more to explain the phenomenon of reasonable disagreements that we discussed before, and also to understand argumentation, adjudication, and how it happens in competition law and how we can manage it. So that's why I think also Justin agreed with me that even if we take his point that competition is not an essentially contested concept, still we will have disagreement because the disagreement will creep in the different interpretations that are proposed before the court, right? So I think in that regard, we are on the same page. It's just that my point is that I consider that there are several essentially contested concepts in competition law, be that the very notion of competition or the notion of restriction of competition or abusive dominance, meaning that we can advance different legitimate, reasonable interpretations of the concept. So then we have to find a way, right? We have to find a way to manage to deal with this kind of uncertainty without pretending that we can eradicate this uncertainty and make the concept fully non-contested. I would even say that making the concept fully non-contested is counterproductive because it will close the capacity of competition law to adapt to epistemic change, right? So you might have an output related notion of competition that relies heavily on, for instance, the model of perfect competition, and someone else might have a more process related or more dynamic, right? So for me, this disagreement is inevitable, and it's something that helps the law progress, right, and adapt, be agile, and solve issues. And I think also Justin would agree that this conflict will happen. We'll just say, okay, you added an adjective, output competition. We don't really disagree about competition. We disagree on the adjective because competition, analytically speaking, blocking someone to get an advantage over something, for instance, is something non-contested. So I think he makes an analytical point and I make a point for adjudication. So I see it more as a complementary work.
Thank you very much. Two last questions, Stavros. The first one is related to the institution, which in most areas of human knowledge is a pioneering, but we are talking about competition law, and it's hard to overestimate the importance of the UCL and the cluster of scholars which not only contribute in explaining but the nature of competition law, but also in its further development and shaping. Can you please summarize or highlight or elucidate on the latest initiatives of the center? And also the next question will be a recommendation to students, but I'll ask you separately.
Thank you, Oles, for your very kind words. Actually, I feel very fortunate to be part of a really vibrant community at UCL. Our Center for Law, Economics and Society, CLS, is in my view a truly active, inclusive and extrovert hub for competition law and market regulation research. Last year alone, under the leadership of my fantastic colleague, Professor Ioannis Llanos, we organized around 20 events on a variety of topics worldwide, and this year promises to be just as, if not even more exciting. So do keep an eye out and make sure to visit our center's website. Just a couple of words about the center. The center was established in 2007 and operates under the leadership of Professor Llanos, a prolific scholar whose groundbreaking work needs no introduction. But Ioannis is also a very supportive mentor, I have to say, and a good friend. The co-director of the center, Dr. Denny Manjari, is an associate professor in competition law and policy in UCL. And Denny, apart from being a really fantastic colleague and a friend, is also a prolific author. I would just like to point to her fascinating research on the interplay between competition law and regulation. Her book, Courts, Regulators, and the Scrutiny of Evidence, is, in my view, an essential reading for anyone interested in these areas. And the center, of course, brings together many other brilliant members of our community, the academic community and beyond, including honorary professors Gyonek Garkanyak and Christina Kafara, Todd Davis, who is currently doing his PhD on theoretical ecology and competition law. And true to Valentine Skora's spirit and vision of interdisciplinarity, CLES welcomes researchers from beyond the Faculty of Laws, such as Cecilia Rickup, who is an associate professor in economics at UCL and has done some really exciting work on intellectual monopolies as a new pattern of innovation and a technological regime. There are, of course, many more remarkable people involved. Please excuse me for not mentioning them all. I just encourage you to simply visit our center's webpage. And the other thing is that we have a very active community of students. So students, I learn a lot from students always. And UCL students are very motivated. They are very active. So they are always keep you on your toes. They participate in the activities. So this is a very nice community. So yeah.
And speaking of students, please share with us your recommendation to students, because you teach and you communicate and you teach in different jurisdictions. You have the experience. You continuously in engagement with various stakeholders. You sense where the key problems and key opportunities for students are.
First of all, I would recommend them to watch your channel. Not only read the books and the papers, because they can learn from different sources. But yeah, I think I would give three. It would be like three recommendations, if I may. The first one would be open to new knowledge, right? Because this is great, like learning new things, and you never really know enough. So there are so many things to learn and better understand. And even if you like think that you learn something, if you just revisit the case, for instance, or you reread the article, then you discover something that the author has said and you didn't notice before, and some new thoughts are created in you. So I find it always very, very enlightening to reread authors, like your cases that I have read once, because then I discover something more. And this discovery process comes only if you are open, and it's really, really enriching for life, for our lives. This goes attached to read the cases or read the articles. I know it's more time consuming, right? But this is how the discovery happens. Not if you summarize the case to win time with the use of a digital assistant on an AI tool, right? Then you lose all the fun part. And then comes my second point, which is develop critical and independent thinking. So contest, right? So nobody is always right. No decision is perfect. No academic article, as far as I'm concerned, is completely perfect. There is always a blind spot, an omission, something that might change. So we need to be able to develop our critical skills and independent learning capacities. And I say that especially in the current digital context, where we often defer judgment to digital tools. These might block our independent critical abilities, and we don't want to lose that.
Stavros Makris, thank you very much indeed for your amazing work and for sharing your ideas with all of us. Thank you.
Thank you so much, Oles.